Hello everyone, welcome to Court with Krissy. I've got a couple of updates, and both of the cases involve siblings. As always, if you happen to miss the first appearance, link is in the description as well as in the video. I hope you like it. Court with Krissy is now in session.
Can I have your name, please, in the Otsego County Jail?
Brian O'Neill.
Okay, I thought you were Mr. O'Neill. I just wanted to make sure. So we're on the record in the matter of People versus Brian David O'Neill. This is file 24-6744FH.
For the record, Mike Roll on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Mr. O'Neill.
Thank you. So, and ma'am, for the record, you are Candida Nelson, correct?
Yes, sir. Yes, Your Honor.
Welcome, Ms. Nelson. I recall your name and your involvement with this case, obviously not only through the briefing, but because you spoke as the victim of this offense at Mr. O'Neill's sentencing. So we're here because at the sentencing hearing, the issue came up about potential forfeiture of the weapon involved. And I asked the attorneys and required the attorneys to brief that issue. I've now had a chance to review the defendant's brief and request for relief regarding the firearm forfeiture, as well as the prosecution's brief in response to the defendant's motion regarding forfeiture of the firearm. The court notes that I've examined those each in detail, as well as the statutory framework under MCL 750.239 in its entirety. And under this situation, while this isn't necessarily a motion, it's a follow-up brief that I required. I also would note that my discretion is simply given the fact that it's a silly motion and a request. Our discretion allows for me to exercise the discretion by barring any further oral argument. I intend to do that today. The attorneys have set forth in their written briefs their positions, and it's ready and ripe for a court determination based upon the circumstances and based upon my view of the statute. So the court notes that first, the statute in question, MCL 750.239, although the defense indicates that it authorizes forfeiture, I view it a little bit different. It requires forfeiture for firearms used in the commission of a crime, and that's because it is used as mandatory language like shall. The operative question, though, for the court is under 750.239, subsection 3, is not about forfeiture, it's about before disposal. And so the court notes that there are several different points that I disagree with, particularly in the prosecution's brief. For example, in the prosecution's brief, there was an indication that there was seizure of a Springfield Armory XDS 9mm from a residence by the Gaylord City Police, and that there was never any formal claim of lost or stolen firearm ever filed by Ms. Candida Nelson with the Gaylord Police Department. The court finds that such a citation, though, turns the statute essentially on its head. And it does so because this is not a situation, and the statute doesn't envision a situation where Ms. Nelson had to make any formal claim with the Gaylord Police Department. Instead, the facts clearly elucidate the fact that at the time this offense was committed by Mr. O'Neill, Ms. Nelson reported that her gun was missing from her safe, and that is enough to trigger a police investigation. There is nothing in the statutory framework of 750.239 that requires Ms. Nelson to incantate specific words or language, or to use the words lost or stolen in order to have the police investigate. She didn't use that language, and the police didn't do anything other than investigate on the basis of her claim that her firearm was missing. Police officers clearly and unambiguously understood that the report from Ms. Nelson was that somebody, likely Mr. O'Neill, took her firearm without permission and destroyed her home. At no point did the police ever suspect Ms. Nelson of wrongdoing. At no point did they ever charge her with the crime. At no point did they ever consider her to be a suspect, because she clearly and articulately reported that her firearm was missing. Mr. O'Neill was clearly then found to have been the one who perpetrated the damage. He pled guilty to doing it. Ms. Nelson, at all times, even during the Crime Victims' Rights Act involvement with the case, was viewed as the victim. She allocated as the victim. Again, nothing has changed that status whatsoever. So the question really becomes under the statute whether or not, as the attorneys argue, whether or not I should find that Ms. Ms. Candida Nelson has somehow failed to do the things that she's required under the statute, or whether, on the other hand, I find that the Michigan State Police has failed to do what they're clearly required to do. I make the determination that the latter applies and not the former. Any error that's been made in this case has not been by Ms. Nelson, the victim of this crime. It's been by the Michigan State Police and or the prosecutor's office, and I say that this way. The statute, MCL 750.239, requires that before disposing of a firearm under the section, the director of the Department of State Police shall do both of the following. In other words, that statutory section mentions nothing about any requirements on behalf of the victim of a crime, Ms. Nelson. It instead clearly and unambiguously requires the state police to do both of the following. First, to determine whether, through law enforcement information network, whether the firearm has been reported lost or stolen. If it has been lost or still reported lost or stolen, and the name and the address of the owner can be determined, the Director of State Police shall, again, mandatory language under the statute, shall provide 30 days written notice to his or her intent, of his or her intent to dispose of the firearm under the section of the owner, and allow the owner to claim the firearm within that 30-day time period. Nothing that I've been provided in the defense brief or the prosecutor's brief indicates a compliance with that statute in any way. First, the prosecutor takes issue with and claims that there was never any finding that there was a report of lost or stolen. I find that to be hyper-technical, not fair, not reasonable given the circumstances, based upon the victimhood of Candida Nelson, of which the prosecutor's office is well aware, particularly because this was a crime victim defense, and the crime victim's advocate, working on behalf of the prosecutor's office, worked directly with Candida Nelson as a victim of this crime. I find that any hyper-technical request to have the words lost or stolen used is not in the interest of justice, and it does not echo the statutory language, which is clear on behalf of the director's duties under the Department of State Police. In other words, as soon as Miss Candida Nelson reports that her firearm is missing, the duty before there's a disposal of the firearm is on the state police to make notification here to Candida Nelson that she is the known owner of this firearm because she reported it to Gateway Police Department as missing. That duty is clear, and it provides then Miss Nelson with 30 days to claim the weapon back under the otherwise known as the innocent owner exception. Even if the state police didn't fulfill its obligations, and it appears that they have not under that section, the next section is additionally applicable and provides an additional 30-day requirement, 30-day notice requirement to the public. Nothing in the information provided by the prosecutor's office, nothing provided by the way of the defense brief suggests that the Department of State Police has yet provided that notice to the public. And so the court notes that even if I were to follow the prosecutor's suggestion, which is at the end of the brief, prosecutor's claim and suggestion is that for all of the above arguments in law and fact, the people respectfully request the defendant's motion for request used by the defendant in the commission of this felony offense be denied, and that the Springfield Armory XDS 9mm semi-automatic pistol be ordered to be confiscated and condemned pursuant to the statute 750.239. The court notes that this creates, if I were to follow the prosecutor's suggestion, an unworkable, untenable, and fairly silly example. Because if I were to order confiscation and condemnation, then the state police requirements under 239.3 still are at issue, and they still require the state police to provide notice, number one, to Miss Nelson, who then can recover the firearm if she's otherwise allowed to possess it, and the state police still has to provide 30 days notice to the public, where then, if the serial number can be determined, the owner can come forward, demonstrate that she's authorized to possess a firearm. In either scenario, even if I were to find that the hyper-technical argument by the prosecution that because Ms. Nelson didn't incantate the correct words, lost or stolen, somehow deprives her, the victim, of being able to recover her firearm that she had nothing to do with the illegal nature of, the state police would still have the same duty if I followed the prosecutor's own requirement to order confiscation and condemnation. I don't choose to do that. Instead, of my discretion, I choose to make a clear finding and a clear ruling that the firearm in question, the Springfield Armory XDS 9mm, shall be released to Miss Nelson as soon as she demonstrates that she's lawfully able to possess the firearm. If for whatever reason Miss Nelson can't lawfully possess a firearm, of course it won't be able to be released to her. But the statutory parts are clear and unambiguous. I don't frankly understand why in this position, why the prosecutor's office is clearly aware that the victim is a victim, that they would take the position that the victim should somehow be additionally punished because of the criminal actions of David O'Neill. I don't understand it, but it's not up to my understanding. That's the prosecutor's position. I simply overrule it, and I grant the defense request to have Ms. Nelson permitted to retrieve the firearm again once, and if she's able to demonstrate that she's authorized to possess the firearm. Mr. Church, can you prepare an order?
Yes, Your Honor, I certainly can.
Do you have questions about the specific language that is specifically that Ms. Nelson is allowed to and required to, or permitted to rather, retrieve the firearm, but she must demonstrate that she's authorized to possess it? Do you need further clarification on that language?
I do not, Your Honor.
Do you have any statements for purpose of appellate review that you'd like to place on the record, Mr. Church?
No, Your Honor.
Do you, Mr. Rolo?
Yes, Your Honor, thank you. It's not the people's position that the statute was implicated as the weapon was found in the defendant's home, in the master bedroom, on her bed, in the room she would share sometimes with the defendant. The weapon was never stolen or lost in the first place. That's why the people took the position they did. Thank you, Your Honor.
So noted. Ms. Nelson, what you'll need to do is once you have a copy of the order that Mr. Trush is going to provide, I'm going to sign, is take yourself to wherever that firearm is being held. And I'm sure that now, given the order, even if the prosecutor disagrees with it, he'll accommodate and let the defense attorney know where the firearm is being housed. Is it at GPD? Do you know, Mr. Rolla?
That's my understanding. It's in their gun lockup. Yes, Your Honor.
All right, and so you'll have to coordinate with Mr. Trush and hopefully with the assistance of Mr. Rolla to find out exactly where you need to go, Ms. Nelson. But as long as you can demonstrate that you're lawfully entitled to the weapon, you should be able to retrieve it. Do you have any questions, Ms. Nelson?
This is my only firearm that I have currently. I have been in the process of purchasing another firearm, just because to have protection in my home. But since, yes, so no, I own no other firearms currently. Correct.
Okay, thank you. Mr. O'Neill, thank you for being here today. I know you were brought up by request of your attorney. The court will be in recess on this matter today. Thank you, everyone.
Thank you, Your Honor.
Nate Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Hamilton.
Mr. Hamilton here, or is he
He's
always in
the-
custody?
He's
Sorry.
with the pretrial confinement
Thank you.
group.
This is so much more. This is so much.
Mr. Hamilton is in current pretrial custody. He's now been escorted in and seated at the defense table next to counsel. We are here today for the continuation of a competency evaluation hearing. This court received on February 20th a report from the Center for Forensic Psychiatry, which is a part of the Department of Health and Human Services here in Michigan. That report was dated February 14th and signed by a psychiatrist of that program. Mr. Carnes, did you receive a copy?
Yes, Your Honor.
Mr. Harrison, did you receive a copy?
I did, Your Honor.
All right, thank you. One moment. All right, according to the report, it states at the time of the current interview, which was back on February 13th this year, it was the opinion of the psychiatrist that the defendant maintained the capacity to continue with legal proceedings, therefore finding that he is competent to stand trial. Mr. Harrison, do you have anything to add to that?
I don't, Your Honor. I've read the letter to the court. I don't necessarily even challenge. No, Your Honor, I don't have anything to add.
Okay. Does the defense request any individual time for an individual evaluation?
I don't believe that will be necessary either.
It's, am I correct if I recall, he's on medication, correct?
He is, and he's doing much better now, ironically. As far as rational expression and that sort of thing, which was frankly one of the issues that arose in both of the crimes for which he stands charged. We've repeatedly made the point in district court as well, and in fact, as the court will note, he was in fact released from custody by the order of the district court because he does not do well in that environment. He presents a challenge to the department employees within the jail itself. And that led us to try and find him some sort of placement in a suitable location. Unfortunately, his mother, who is also his guardian, has been engaged in that effort through Mr. Heiniger with our office as well. And we've been completely unable to find a suitable location for Josh to be, and I remain deeply concerned with his not only his ability to thrive in jail, but perhaps some potential regression due to the additional stress of being incarcerated. None of that is, of course, probably appropriate for consideration under the court rule with regard to bond, and even more difficult in this case, he was already subjected to bond, and in fact, his bond was forfeited because of a subsequent incident. So this case presents a remarkable challenge, not only to our office as a defense lawyer, but the entire system, including the jail, with regard to what to do, quite frankly, in the next step. I don't know if it's my province to seek guidance from the court in that regard, but I will happily do so. Thank you.
All right. Mr. Carnes, anything to add at this time?
No, Your Honor, the people have been emailing as well, trying to work with defense on some other placement, and I echo Mr. Harrison's frustration.
And there wasn't an evaluation requested for criminal responsibility. Am I correct, Mr. Harrison?
I can't recall. Let me check. It seems like I would have requested both.
You asked for a competency exam on the 27th of January.
Okay.
I don't see a responsibility exam. Madam Clerk, do you see one?
I seem to remember it being discussed. I do not see a request.
Yeah, I don't see a request. All right, so Mr. Harrison, of course, if you get the responsibility evaluation, that's up to you. The court could on its own issue an evaluation. Sometimes I prefer that come from the defense because I don't know enough about Mr. Hamilton.
Here's my hesitation, Your Honor. Irrespective of the nature of the crimes here for which he faces charges, they're assaultive in nature in both instances. One is in fact a misdemeanor, and one he would not score any significant sanction from the court. Obviously, my consideration is with the procedures and frankly, real world experience with the forensic center, it simply doesn't make that much sense.
It's up to the, so first of all, I don't know much more about Mr. Hamilton other than what was expressed in the letter. And whether or not the court were to refer the defendant for an evaluation for insanity, or what we basically call criminal responsibility, really should rest on the defense, because it's a tactic that the defense can assert at trial. For instance, if it were to come back that he lacked criminal responsibility at the time, it does not require the government to dismiss the case, and it doesn't necessarily help him get out of jail. In fact, a determination of criminal responsibility could be used that I could assert that he needs to be placed under treatment. And if he doesn't, they don't have any bed space available, he might end up sitting in the jail longer. So really, tactically, and I think professional responsibility falls more heavily upon the defense counsel. Yeah. And I'm not saying Mr. Harrison should or shouldn't, because he knows his client much better than I do. Obviously, I've only met Mr. Hamilton a couple of times here in the courtroom. So whether or not you do, that's up to you. Now, as for criminal responsibility, as for competency and bond, those are two somewhat unrelated matters.
Well,
It does become an issue that when a defendant is, let's say that the government, the defense requests to have his bond modified by the court and have him released to a hospital. I can't control whether or not he stays there. There is no lockdown facility necessarily. So, but I would want to know a lot more about the defendant. Sometimes the defense attorney will come in and just kind of ramble and say, therefore, I want an evaluation. I'm sorry, I want the bond modified. well, I gotta know what his mental health is, what his diagnoses are, what do the doctors and treatment providers say, and I've gotta have something that gives me comfort to believe that that's appropriate and that he'll be compliant, and even more importantly, that the public will be safe and the defendant will of course be safe. So, Mr. Harrison, I think that's about all I can really say as to your guidance, question or hint.
No, I understand, Your Honor, and it's a practical consideration at this juncture. Even supposing we were able to convince the court to reinstate bond here, we don't have a place for him to go right now. And that's really the ultimate irony as far as I'm concerned.
And I would want to know more about a defendant's prior history. For instance, let's say this case, I don't really know much about it. Let's say this case involved firearms. If the defendant had prior felony convictions and it still keeps giving access to firearms, that would be concerning. If the defendant had prior criminal history that involved assault behavior, that would be concerning. If he doesn't, then I'm going to look at what are his diagnoses, what are the treatment needs necessary, and so forth. So those are factors to consider. All right. At this time, the court has now found, or does hereby find the defendant competent to stand trial. The court does order that he continue to receive his medication to help maintain his competency, which was exactly what they at the end was commented upon by the psychiatrist. And if Mr. Harrison chooses to do a motion, and we don't have time today, so make sure you coordinate and get it on the docket.
Exactly.
All right, gentlemen, thank you for your time.
That is our anticipation, Your Honor, and I appreciate your insight. Thank
Mr.
you.
Hamilton, I know it sounds like you want to talk. I'm going to tell you, make sure you talk to your attorney first. I know you've got a mom out there who cares. Make sure you talk to mom, okay?
Yeah, I got places to go.
Okay.
My
Well,
family, uncle.
You're going to work with your attorney and I'm going to make sure you get due process. So,
And I really like, this jail's just messing with my head hardcore. I'm not used to, this is my first offense on anything. 43 years of being a law-abiding citizen now.
okay.
Me and my brother get in one fight and it's over. I'm thrown to the wolves.
All right, well, let's hold on. Let's take a break. And I'm going to trust that Mr. Harrison, because he generally does, will do a good job making sure he gives you good advice and helps you get through this process.
Yeah, I trust my attorney. I just like to go home with my mom.
I understand. All right, not today though. Thank you. We're adjourned. We are next going to take up the case of People of the State of Michigan versus Craig Stewart, file 24-13965FH.